doing a roving inquiry in a writ petition which is not allowed. My lord, if your lordship kindly first takes up, this order has also been challenged by the board. I think that matter is also appearing.
But there is a direction, my lord, to appear analogously, but matter is not appearing.
I don't know.
On the last occasion, my lord.
That is it.
Is it appearing in the list?
But the number is smaller.
Number and name different.
Here is wrongly mentioned. And the cost
Can
type.
be taken up.
Cost title wrongly.
No, not appearing together immediately after this matter.
Yes.
MAT 1382 is appearing in the list. Huh?
1382 appear করছে
কোথায় লিস্টে আছে? Yes, it is here.
I don't. It's there. Bas, ঠিক আছে. My lord, lordship may kindly takes up and comes to the prayer in the writ
Appellant
petition.
there.
Board.
In that matter. So there is a mistake, so no difficulty. No, once you are there, then no difficulty.
শুধু একটা কথা বলবো পুরোটা 18
My lord, before
Just
going
1
to
minute,
the
let us
impugned
go
order,
to the impugned order first.
I'll be praying your lordship to see the prayers.
Yes, just 1
My
minute.
lord.
Let us go to
Yes,
the
yes.
impugned order.
Kindly takes up the memo, my lord.
Second justice copy dao.
Starts for internal page 13.
You need not have to. Please just wait.
It's huge, my lord. There are many appearances
Yes.
are there.
What? There is already a
Similar-
CBI which is
Yes,
conducting.
it
They are
is
not-
there. CBI has also given an affidavit saying that these cannot be. Kindly now takes up, my lord, my stay application. Page 46 is the prayers in the writ petition, and thereafter I'll draw your lordship's kind attention to the affidavit of the CBI. Thereafter, order passed. Kindly comes to page 46. Writ petition, my lord, relates to a process of eligibility test conducted in 2014 and 16.
No, they wanted a supply of the OMR sheet.
Yes. That is the scope of the
That
writ
appears
petition.
to have been destroyed or something like that.
Now, my lord, kindly comes
In order
to,
retrieve it.
my lord,
Court has passed an order to retrieve it.
yes. Now, my lord, kindly comes to the CBI's affidavit, which is at page 50 onwards. This is the affidavit of the CBI dated 14 June 2024. No, not 14 June. This is affidavit dated 16th April 2024. Kindly comes to paragraph 16 at page 59. Lordship is at page 59, my lord. May I place the paragraph?
Just 1 minute.
Mark for. When the matter shall be taken up for final hearing as specially fixed matter such and such, there will be no adjournments. We were ready to do the matter. Now, my lord, on 30th, kindly comes to the order which is passed on 38. It starts from page 158. The Honorable Trial Judge extends the period, my lord. Several applications are filed, and thereafter the time to file affidavits is extended. Affidavit in opposition filed, my lord. Affidavit in opposition was also filed.
What is the division bench? This matter.
My lord,
Supreme Court directed this division bench to continue with the matter which
no, this is not that matter. That is a different matter, my lord. That has been mentioned. Now, my lord, page 130, 163, my lord, the issues are fixed by the Honorable Trial Judge. The issues are starting from page 170 onwards. This order was subject matter of a mandamus appeal before your lordship. Your lordship was pleased to pass an order observing that the maintainability point has to be taken up fast. That is also annex matter. I'll be drawing your lordship's kind attention to that. But after that, when the matter is, my lord, ready for hearing and the affidavits have been exchanged, my lord, this order, which is, my lord, passed by the Honorable Trial Judge, was passed. My lord, kindly, my lord, this order was appealed against in page 189. This is your lordship's order of this honorable bench. This is arising out of the order dated 3/5/2024. And your lordship was pleased to, my lord, dismiss this appeal, observing that paragraph 13, we hope and trust that the point of maintainability shall be decided by the court of first instance as and when the same is raised, or the occasion or to decide the same are before the dealing before
Arise before dealing, before delving upon to decide.
My lord, there is my lord, the
No, I can read
printing
it.
has not come in my my lord copy.
In my copy, at least you
I
can.
think it is legible copy which has been supplied.
Yes.
Now, my lord, at this stage, when the matter is ready for hearing, this order, in my humble submission, would amount to, my lord, roving inquiry and will be, my lord, hit by the principles of, my lord, this Sadananda. Hello, my lord, kindly seeks, my lord, I am referring to this judgment 2008 4 SCC 619. The matter may be taken up in its entirety, my lord. We are ready to do the hearing. Maintainability point may be thrashed out. It may go into the merits.
You are representing the set of the persons
Who had added.
who never participated in the examination.
No. We participated in the examination.
Their name was shown in the.
No, nothing of that sort. That is, my lord, SSC matter. This is, my lord, different.
Also,
these matters, my names have never been shown.
CBI affidavit revealed certain facts.
We are not those
from
persons.
The first paragraph to the last.
We are not those persons. We were, my lord, appointed much prior to this particular person who is named in the affidavit of CBI came into play. Entire thing he has done after, my lord, we have gone into the appointment. So, my lord, the appellants before your lordships are, my lord, persons who had come and said that whatever said and done might have been done after the appointment of their after their appointment, so they cannot be. That is on merits. That is the honorable trial judge will decide. My humble submission, my lord, kindly comes to page paragraph 58, my lord. My submission before lordship is the subsequent order which has been passed even after the stage when the CBI has said that they have not been able to test out would amount to a roving inquiry which the writ court cannot do. May I just place one paragraph? It is settled law.
I read that.
Yes, paragraph 8. It is settled law. But this is also in a recruitment process. There are several judgments to that effect, but I will not, my lord, pile of books before a lordship. My lord, only one judgment. That is why I am reading. It is settled law that in such writ petitions, a roving inquiry on a factual aspect is not permissible. Oh, the 84 page 619.
Yes.
The High Court not only engaged itself into a factual, not only engaged itself in a non-permitted fact-finding exercise, but also went on to rely on the findings of an amicus curiae, or as the case may be, the scrutiny team, which in our opinion was inappropriate. While testing the fairness of selection process, wherein thousands of candidates are involved, the High Court should have been slow in relying upon such microscopic findings. Here, my lord, the Honorable Trial Judge is going to find out make out the microscopic findings, my lord. And, my lord, it is not for the High Court to place itself into a position of a fact-finding commission. that too, more particularly at the instance of those petitioners who were unsuccessful candidates. Here also they are unsuccessful candidates, admittedly. The High Court should therefore have restricted itself to the pleadings in the writ petition and the say of the respondents. Unfortunately, the High Court took it upon itself the task of substituting itself for the selection committee and also in the process of assumed date. In the process, assumed the role of an appellate tribunal, which was, in our opinion, not proper. Thus, the High Court converted its writ petition into a public institution without any justification. Well, here also,
In what context it is used?
yes,
There, the High Court wanted to scrutinize whether all the marks which have been allotted is correctly allotted or it is a correct one or not. In that
Yes.
perspective, this observation has come. Can it be applied in all conceivable situation?
then I can, my lord, find out. I have those judgments.
The decision is what it is decided in the perspective
Actual
of
background. And then, my lord, I will come out with the other decisions also in
Out with the other decisions.
different facts of circumstances. I will come out.
Because I have read this judgment, it was in that context because the High Court was entering into the marks, allotment of marks, whether it is correctly allotted or not. That is not. I have also dictated today, I have said, no, you can't. Usurp the power of the academicians or the teachers who have the expertise in their respective fields.
Yes,
The
that
High
is.
Court should not.
Now,
Unless there is a very
that is in the here also.
This is not a case. This is a case of a larger interest.
My lord, that is my humble
Now,
submission.
let us see,
This is, my lord, a case.
Mr. Gupta is also.
I can bring other judgments also in this aspect.
That we will consider.
Then I'll, my lord, kindly keeps it in next date. I'll bring other judgments also.
Of July.
Yes.
My lord, there the court has said that any further investigation by the CBI through engaging other agencies, the cost is to be borne by the board.
Yes. You are concerned with the cost.
I am concerned with that. My lord, investigation against me, I'll have to bear the cost.
Why not?
My lord, is there
Why
any
not?
precedent anywhere?
Why not? You have no allegiance to anything. You are a neutral body. Your existence is because of the public and the citizens of the country.
Of course, yes.
In the education system. Now, being a limb of the government, you are a limb of the government as well. If something is done, then who will bear the cost?
My lord, the cost, my lord, in respect, my lord, of every criminal offence. In respect of every criminal offence, investigation is carried on.
Come, I will consider your case. Very limited. Third.
Achha, there are 2 points. There were 2 aspects. By what it remains is the what we call as the scanned copies or the digital data. Lordship, these digital data, what the CBI has indicated in their report or in their affidavit is that there were 2 set of scanners which were available with this agency while scanning the OMR sheets. One was the Seconic type printer scanners and the other one was the ADF scanners. Now the ADF scanners used to scan the image of the OMRs and those images vis-a-vis with the answer string, if I may call it as, those were stored in an appropriate manner. Now, in this set, it has been admitted that the images were destroyed, but the scanned images, the scanned answer string, which were the output of the Seconic types, that were retained, Lordship.
If any editing is done, the software or the computer will indicate that what was the time, what is the date when the editing is done in the document.
Lordship.
There is no difficulty in retrieving if there is any.
That is already with them.
My lord, so far as the board is concerned, my lord, we are not against the investigation.
They are more concerned with the
we are
money, not.
And Lordship,
Not only board.
so far,
My lord,
if
I
I
am
may
not concerned with
reply
the
to my
investigation body. Go on. I am
No,
not
that-
against this.
I know you are concerned with the money.
Exactly.
Yes.
Yeah,
Lordship,
where
if I
from
may
do I see?
reply to my esteemed senior friend
Lord, I-
representing the board, Lordship, it was the part and parcel
The
of
board
the
has
board.
engaged Mr. Gupta, the board has engaged Mr. Sanyal.
I couldn't follow.
তাহলে সাবসিডাইজ রেটে করে
The role is, we will consider it, don't worry.
Yes.
For the money part, no difficulty, we understand. Cite the judge.
Yes.
Mr. Lahiri, the learned advocate appearing for the appellant in MAT 1